our Facebook page at KUTV Kenya. And on to our first story now. An independent judiciary must be free of undue influence from the executive and legislative branches and must remain committed to the preservation of the rule of law and the protection of individual rights and liberties. Those are not my words. That quote, dear viewer, is part of the statement to newsrooms from the Katiba movement, accusing the head of state of utterances that threatened the judiciary, I beg your pardon, on his Madaraka Day address concerning the BBI and calling him to desist from such.
As I said of the judiciary, their decisions must consider the letter of the law, but fundamentally, the spirit of the law must also guide them. I say so with all humility because the spirit of the law is the light that will illuminate the burden of the choices that they make.
Tough talk from President Uhuru Kenyatta during the 58th Madaraka Day celebrations that faced the judiciary squarely has continued to attract varied reactions in the nation. In a statement to newsrooms, the Katiba movement, which is among the respondents in the BBI appeal case, accused the president for what they termed as a pattern of attacking judges and the courts for rulings he disagrees with.
If the court had subjected its decision to stop BBI to a cost-benefit analysis, in other words, if it had considered the burden of choice, then there are questions the judiciary would have asked. If we indeed were at a constitutional moment, is a decision against BBI a decision in support of the status quo? If BBI were to be stopped, who carries the burden of choice?
The movement referred back to the 2017 nullified presidential elections that birthed a heated atmosphere between the executive and the judiciary. The Katiba movement noted such comments not only as challenging the reputation of the third co-equal branch of the state government, but also its independence and the personal safety of judicial officers. They further pressed the president to observe his sworn duty to uphold the constitution and the rule of law, apart from doing everything in his power to preserve the integrity of the judicial system and involve legal mechanism for redress.
Let us be balanced in our comments. Let us realize that we have an important judicial process that must be handled in a very sober manner. And let us not begin to, as it were, prosecute or defend our respective positions.
It is clear that the judiciary, which just embraced a new leader in Lady Justice Martha Koome, faces a test not new to it in the interpretation of law, having to determine a matter in which a fellow arm of the government